Good evening, everyone. Today is Wednesday, November 4th, 2020. It is now 5 p.m., and I'd like to call the City of Homestead special call meeting of the City Council to order. If I might, I'd like to take a privilege to deviate from the agenda from just a moment. And in recognition of what this city and this state and this country has been through since we last met in person, and what comes before us in the days ahead, I would ask that those of you who are so inclined to please stand and join with me in the Pledge of Allegiance to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. Please be seated. Madam Clerk, we have a roll call, please.
Councilman Fletcher, Councilwoman Bailey, Councilman Shelley,
Here.
Councilwoman Avila, Councilman Wrong, Vice Mayor Faircloth Staggers,
Here.
Mayor Losner,
Here. And a note to council members, we've ceded control of your microphone to each of you individually, so you can control when you buzz in, and we'll see if this group can behave itself after 8 months apart. I need to read the COVID statement into the record. This is a hybrid meeting which allows for the public to participate by either calling in, Cisco WebEx, or physically appearing. Please note that during COVID-19, there will be limited occupancy available in the council chambers. Face coverings must be worn by attendees at all times. In addition, the public will be subject to temperature checks and COVID screenings will be required. This meeting can also be viewed live on the City Access channel or city website at cityofhomestead.com. The city will be accepting public comments as part of the meeting, which can be emailed to publiccomments@cityofhomestead.com. Public comments are limited to 300 words per comment. Public comments should include your name and address prior to the comment and may be submitted up until 30 minutes after the end of this special call meeting and will be included in the minutes. Our first and only item of business tonight, tab 1, is car number 3040. Mr. White?
Yes, Mayor, council members. I guess I'll digress for a moment and just start with where we left off, where this left off. If you recall, back in May, the city received 2 notice claims, Harris Act claims, presented to the city from the Alders. Back earlier this summer in July, we brought those items forward for your review and consideration. At that July 29th meeting, on the eve of that meeting, there seemed to be some agreement between the Alders, the city, the HARB, with regards to a possible solution or resolution with respect to these claims in a settlement. So at that juncture, the Alders had agreed to extend the time frame under the statute that was required for the city's response in order to give us some time to meet, to discuss, and potentially come back to you with a settlement for your review and consideration. So that time frame was extended. Subsequent to that meeting, we did have discussions and meetings with the Alders and with representatives from the HARB. There was an opportunity for the base to submit a REPI application this year. Due to COVID, the extension timeframes were extended, which allowed for that application to be submitted. The settlement agreement that is before you this evening is a settlement agreement that the Alders are willing to accept. I'll preface this by saying there is some disagreement between the parties with regards to the timing. The base would like the base had requested and would like for there to be a tolling agreement in place, put things on ice to give an opportunity for the REPU program to play out. The Algers are not amenable to that. And so the settlement agreement that's before you this evening does a couple of things. One, it is the bare bones that's required. It's necessary for us to meet the requirements in the Harris Act. It provides for a limited exemption to the property to allow for the restoration of the 1 per 5 on the property, the ag property that the Algers own under the APZ. It does also provide for an exclusive window of 3 years, an opportunity by which the Algers have committed to proffer those rights available, make them available to the HARB for purchase through the REPU program. That's a 3-year window, a 3-year exclusive period. However, the settlement agreement does provide for a caveat to that, which stipulates that if there is a challenge by the U.S. government, the HARB, the Air Force, or any entity on that behalf who challenges the validity of the settlement agreement, if it's approved, then the 3-year window would become null and void and would go away. The agreement also provides that if there is a challenge with respect to the settlement agreement, that the Algers would participate in the defense of that challenge. And it also provides that in the event that there is a challenge, that the Algers don't get to walk away from this and then go file in circuit court. They have to let this play out. So there needs to be a final adjudication from a court with regards to the settlement agreement prior to the Algers picking up their Harris Act claims and filing them in circuit court. There is also provision in the settlement agreement which provides that if the city is acting under a court order, that compliance with that court order would not be deemed to be a violation or a breach of the settlement agreement on the city's part. So with that, I'm happy to take any questions that you may have. I digressed on a lot of the history because I think you all have that, but I'm happy to answer any questions that you may have. And Mayor, also, the Algers are present this evening, and so is representatives from the Air Force Base as well, who I think would like to speak whenever you all provide.
Thank you, Mr. White. I think I would look to council to see if they have any initial questions predicated upon your presentation. No questions from council at this point. Would the Algers or their representative wish to make a presentation?
Good evening, Amanda Quirk-Hand on behalf of John Alger, Richard Alger, in their capacity as trustees, as stated in the May 21st claim letters the city received and is already part of the record tonight. As your city attorney mentioned, obviously the city received notices of Birch Harris claims on May 21st in the amount of $13 million approximately. It covers 192 acres in the APZ-1. The Algers own almost the entire APZ-1 that is in the city of Homestead, and there's only one use that's left on that property after the 2010 HARB ordinance. That's agriculture. At this time, you know, the agriculture business has taken a big hit from forces that are outside everybody's control, market forces, weather forces, and things like that. So John will talk a little bit about that, but right now that property has one use and one use only based on the city's adoption of that 2010 ordinance. The Birch A. Harris claim provides a cause of action for a private property owner to make a claim against the local government. It states, "The legislature determines that there is an important state interest in protecting the interests of private property owners from such inordinate burdens. Therefore, it is the intent of the legislature that as a separate and distinct cause of action from the law of takings, the legislature herein provides for relief or payment of compensation when a new law, rule, regulation, or ordinance of the state or a political entity in the state is applied unfairly affects real property." That couldn't be more true in this case. In this case, the claim is based on subsection E1. In the case where the property owner is left with existing or vested uses that are unreasonable, such that the property owner bears permanently a disproportionate share of a burden imposed for the good of the public, which in fairness should be borne by the public at large. This is the best Bert J. Harris claim that I can think of. In this case, the Algers own almost the entire APZ-1, and the 2010 ordinance was enacted, the stated purpose was to protect the Homestead Air Reserve Base, an entity of the federal government. So this is a burden that should be borne by the public at large, and the Alger family should not be forced to bear it by themselves. That is protected by the Bert J. Harris claim. That is protected by the Bert J. Harris Act, and that is the impetus for the claim. At this time, their settlement agreement provides for a restoration of the 1-on-5 in the APZ-1, and it only gets the Algers back to ground zero. That's it. It's just to treat the Alger property the same as all the other private property outside the UDB, ag and 1-on-5. I have 3 maps to show you that I think are relevant, that I think you have to keep in mind, because there has been several letters that have been sent to the city by the defense community stating that the action by the city to approve the settlement agreement is going to be devastating to the Homestead Air Reserve Base. I have to disagree. There is another APZ-1 on the base that is in the county. The county maintains 1-on-5 in the APZ-1. The reason that the county will not take away the 1-on-5 in the APZ-1 is because they know that it will give rise to a claim for compensation. This is the least intense use that you can keep on the piece of property without being forced to pay compensation under the state, federal constitution, or the Bert J. Harris Private Property Rights Act. There is just, as further example, at the time that the 2010 ordinance was adopted, there was actually a REPI application that was pending in the APZ-1. So the base had abandoned that REPI application because the city acted to take away those rights, and then the base felt that they did not need to pursue the REPI program further in that APZ-1. In this case, leaving the Alger property bare with just the ag use, there can be no doubt that compensation is going to be required under the Bert J. Harris Act. The only hope is, if we get to the damages section of a trial, the city will have a consultant that does a damage estimate and appraisal of those rights, and you might be able to get it down to some other 7-figure number, but it's 192 acres, so there is no doubt that this is a multi-million-dollar claim. Today is the opportunity to settle. The Bert J. Harris Act provides for a 90-day pre-suit window, and it is in favor of the local government because it gives the local government plenty of time to meet and discuss and try to come up with a resolution to resolve the claim without having a claim filed in court, which triggers notice to the insurer and liability for attorney's fees and costs. Not just your own attorney's fees, but my attorney's fees and costs as well. One comment that I heard was, well, if we settle this claim, won't it open the floodgates for more claims? And the answer is no. There is no other private property owner who has preserved a claim. So this is the only claim that there is. This will not open the floodgates. As James stated, the base has asked for a tolling agreement. At the end of August, the base first asked for a tolling agreement in order to pursue the REPI process. As you recall, when we were here in July, and this council met twice on this item in July 22nd, and that item was deferred, and then on July 29th, it appeared that we had an agreement that was amicable for everybody, which was provide a 3-year exclusive window for the base to try to obtain REPI funding and restore the 1-on-5. The reason that the base had asked for that multi-year window is because there is a lot of uncertainty with the REPI program. They have to figure out where they're going to rank amongst all the other applications that are filed. They have to see what the total amount of funding is going to be. There are many unknowns as to whether funding is even going to be available. At that time, then, they'll go ahead and get an appraisal and make an offer to the landowner. there are many parameters that are they're outside everybody's control. We have to see who applies and how it's ranked and what funds are available. On July 29th, we said, okay, I understand, that makes sense. I'll give you 3 years, that's 3 application cycles, we're not gonna do anything. Go ahead and see if we can get the REPI funding. We thought that that was a great amicable resolution, and this council unanimously directed the city attorney to work with me to come up with a settlement agreement. What is before you tonight is the bare bones that will resolve this matter. There are no extras. It is 1 on 5 and the 3-year window. At the same time that the basis asked for that additional tolling agreement, when they first asked me at the end of August if we would agree to a tolling agreement, I said no, and they said, well, then we don't know if we're going to submit the REPI application. So luckily, they changed their mind. They did submit the REPI application. That application is out there. I don't know what it says because I've asked for a copy. It has been declined. I don't know what the scope of what they envision to purchase. I also know that they have an idea of the value that they're probably thinking they're going to offer. I don't know any of these things. So there are many unknowns. I think there is a lot more knowledge on the basis side, but at this time, we just cannot extend this claim any further. The claim was filed in May, and this process has been going on for 10 years. 12 hours after this council voted on July 29th to direct a settlement, the base reached out to me to have a call about the REPI. So it is moving, and we are hopeful that it comes to fruition ultimately, but there are a lot of unknowns, and I don't control that process. In conclusion, I would just remind you, you've received a bunch of letters of support from the defense community, but you have to look out for the city of Homestead. And the city of Homestead is going to be facing the damage claim. Nobody else is offering funding to help you defend a claim or pay a damage claim. So I would encourage you to think of the city of Homestead right now and whether or not you want to expose the city to this potential liability. What is before you is just the very bare bones that will resolve this claim. It is separate and apart from the REPI. Like I said, we are hopeful that the REPI is successful, but I don't control it, and even the base doesn't really control it. So we respectfully ask that you're going to restore the 1 on 5 to get the algae back just to ground zero. That's it. The algae, as you know, are not litigious. They are not adversarial, but at this time we need a resolution. So I am open for questions from any of the council members, and if there are no questions, I would like to reserve just a minute for rebuttal at the end.
Thank you. Any questions from council at this point? No? Okay. Thank you.
Good evening. My name is John Alger, Alger Farms. Been a lifetime resident of Homestead. My grandfather started farming in Homestead in 1934. That's 86 years ago. I'm the 3rd generation on the farm. The 4th is actively participating. Matter of fact, they're still planting right now, and will be for many hours. We love farming. We'd love to continue doing it for the rest of our lives. There's a lot of things out of our control that have made it unprofitable for the last 10 years. And but my intent is to continue to farm. We don't want to put houses out there. That's not really what we're all about. But left with no options, we need to get some value out of our property because I can't even use the money, I can't even use the land to collateralize my operating loan until I get this back on. We're tired. My wife started sitting on the J list in 2006. A lot of hot air. For 10 years, we've been back and forth. Hot air, wasting our time. I'm done. I'm through. They sent out a letter this afternoon saying they want to wait till January. In January, it'll be February. It'll just kick the can down the road. I'm ready to step on the can. Then there's the amendment there that says if after 3 years we don't accept what they've offered us, That's like Don Corleone. They're going to make an offer we can't refuse. So sue me now or sue me later. I'm done. I'm through. We're filing next week. Tonight, it cost you $0 to get out of this claim. Next week, we go to work. It costs money. And I'm very sorry that I have to take an adverse position in my own city. But I've got to protect my family's property. That's what I intend to do. Thank you. Any questions?
Counsel?
No?
Thank you, Mr. Alger. All right. Is there anyone first here in person who would like to address the item before us, or do we have anyone online?
Larry Ventura, Homestead Air Reserve Base. You all know me for a long time. Just a moment while I put my spectacles on so I can read. First, I'd like to read something into the record. Dear Mayor and Council members, my name is Larry Ventura. For the record, Homestead Air Reserve Base. I am the Mission Sustainment Program Manager for the base. I'm here to provide comments on the proposed settlement. By passing the drafted resolution tonight, the city is essentially ruling against the Air Force in advance of any settlement, which gives no incentive for the landowner to settle with the Air Force. The city bestows full development rights now. It allows the landowner to walk away with no obligation or need to honestly consider whatever REPI offer arises. Any settlement must protect the public interest served by the regulations at issue, which is compatible development. The public interest is best served by not allowing families to live under an accident potential zone. Let me also state that despite the voluminous information HARB shared with the city over the past few months, we only became aware of the proposed settlement agreement on Tuesday, and not because the city provided it to us, only because it was posted on the city's website. However, there is still a mutually beneficial solution. The Air Force can continue to fly, the landowner can continue to farm, the city can continue to govern, everyone enjoys the holidays, all parties can meet back here in January to discuss the results of the REPI package, which will be known by then. We have a potential solution that can work for everyone, but in order for it to work, everyone needs to remain at the negotiation table. The Air Force remains committed to staying at the table until a mutually beneficial solution can be reached. I'm going to say that I am not a private attorney. I am restricted by what I can do and say, okay? I work for the Air Force. I have to represent the Air Force, and I cannot just go off. I'm not going to attempt to go over the last 10 years of what went on with everybody. I couldn't possibly do so. You wouldn't want to hear it. The Air Force has already provided to you several papers on our legal position, how we feel and what has happened over the course of this whole the last 10 years. I hold no malice or ill will toward the Alger family, and for the Air Force's part, we have tried. I will agree with Mr. Alger that we didn't get there, but I'm not going to let the Air Force take full blame for that either. It is known that the Air Force was agreeable twice to do different offers made by two different attorneys hired by the Algers, and due to no fault of ours, they did not accept either one after they switched attorneys. You have to switch attorneys, things go on. I don't blame Mr. Alger for that either. But it's not, I don't want the impression given that we just did this and didn't want to resolve this. That wasn't the case. The areas out in the northeast of the base are also being addressed. The areas that, as far as the REPI package goes and not being able to see it, those are not shared because the Alders are not the only ones in it. I cannot share them with them. I provided what I could, which was a calendar showing when the decision would be made. I provided a document showing it had been uploaded to the Department of Defense. And if they really needed to know more and wanted to say, well, look, can you give me a little bit of this or tell me about that or how many acres, I would have seen if I could find out and say, look, could I give them at least this or talk about it or give some numbers? But there was no phone call back. And if that's what we needed to make a deal, I would have tried to do that to make a deal and see if I can get something. But I'm not authorized to turn over the report. They just aren't turned over. Nowhere in the nation are they turned over. It's not just here in Homestead. So I will say again, I would like to reach a deal. I mean no harm to the Alders. I would like everybody to walk out of this hole. I would like the city to walk out of this hole. I want the Air Force and the surrounding community that depends on the Air Force Base to walk out of this hole. And I absolutely want the Alders to walk out of this hole. We have an option to do that still. We will know whether we've been selected, very simply put, in a month. It's next month when they're due out. Maybe it works and it doesn't. I don't know. But I know we ought to at least give that an opportunity. And no matter what has been put forth tonight, there is no reason we can't wait till next month to make a move here and make a decision that is in the best interest of everyone. I do truly wish, and the Air Force wants everybody to be whole and walk away with this good where no one gets harmed and everyone gets what they want out of this. I'm going to close with that because, as I said, I'm not free to just go off the tracks and say what I want to say. I've already done more than I was intended to, but I want to set the record straight on certain accounts. Okay? If it's all right, I'm going to give this to the clerk, and I'm here if you have any questions afterwards.
Hang on just a second. Let's see if thank you, Mr. Ventura. See if there are any questions from council as to the points you were making. No questions? Well, help me. The sum and substance of the letter that you issued, I think I first saw it yesterday, your short one-page letter. The sum and substance of it was a request for a tolling, let's just say for sake of argument, 90 days till sometime in January. And correct me where my perception of the short-term process is wrong. I need to understand something. The package has been submitted, and that in January it is anticipated that the application will, A, be ranked from packages submitted from all over the country, and B, funding to pay for those ranked packages or to be applied to those ranked packages will be known. Is that correct? That's what happens in January? Is that what we anticipate to happen in January?
So let me back up, see if I can explain it properly. So the packages were in fact submitted. We got done what typically takes, let me say, 3 to 4 months in about a month. We made sure that we got that done. That was a Herculean effort to begin with. It got submitted, yes. The actual calendar, when it is due back, is actually due, late December, actually. What we have been told verbally was like any other government entity, sometimes, or any entity, sometimes these things don't always come out on time. So on occasion, it will come out in January. So in order to be safe is why we're saying January. And the tolling agreement, yes, I asked till 1 February to account for that. Know that I originally asked for 12 months, is what the Air Force did, so as to allow the entire REPI process to take place, Mr. Mayor, including the appraisal and the monies to be transferred and all these other things that have to happen. The Alders did not agree to the 12-month tolling. In fact, prior to that, we had asked that they agree to sell for fair market value. They did not want to sell for fair market value because they don't know what that is. Okay, I'm reasonable. I get it. So let's toll for the 12 months then so that we can find out, get the appraisal done, and then we have a dollar figure to offer if we are accepted. They said no to that. So it was my third offer, then let's at least toll till 1 February to be accurate so that we at least know if we've been selected and can continue from there. So by then, perhaps, as I said, late December is when they're supposed to come out. What we will know is if our package has been selected for funding. Okay, the Algers, as I said, they're not the only ones in there. I can't talk more to that, but the Algers are our number one priority. The number one priority in our package, it is a 5-year package, so you know, is the Algers. So anything comes forward, it's for them. Now, the whole process, I don't want to get wrong. There is a process of where we are notified that we have this, and then there's a process they go through, which is going to include surveys, appraisals, the county who's our partner having to go back and re-sign there's a document that gets re-signed as we go along with what we know so far, and the monies that are available, if there's any other partners that are going to come in. There's a lot of things. I cannot tell you, because I don't have the book in front of me with all the steps, and I'm not the REPI program manager, exactly what happens when. What I can tell you is if we are selected, then a process will take place that will get us to a point where we can have an actual appraised value to offer the Algers.
I guess what I'm getting at, trying to clarify, is February 1 only gets us to knowing whether or not we've been selected. If this site were selected, that then triggers surveys, appraisals, and partnering with the county, I think you said.
Correct. They are already our partner, and yes, there will be surveys and all those things done. 1 February was a minimum tolling we asked for to at least know if we've been selected and have something in front of us.
Okay, so what I'm having trouble understanding the positioning or the request for the tolling until February 1st is if this is what's before us is a 3-year agreement by the Algers to sit on their hands as to residential development request for the purpose of going through 3 REPI cycles, I'm having difficulty understanding what February 1st really does for the base, or how that addresses the concerns the base may have in light of the fact that this can potentially roll over 3 years, and you've indicated that the package may be for a 5-year process.
The package is what they ask of REPI now, see if I can answer these for you, is a 5-year, as I said, this is not the Alger property only, and it is the way they do it now, things have changed over the years, is they tell us everything that is a holistic kind of thing that you're looking at, and so that's where the 5 years came from. The 3 years came simply from, I wanted to be reasonable, and I didn't want to ask Mr. Alger to be sitting there for longer than that. But at the same time, I know you don't always get selected on your first go around. Sometimes you do, sometimes you don't. Depends on the strength of your package. So I thought perhaps 3 years was a reasonable option is where the 3 years came from to give us a second and third bite at the apple. If we did not get selected this year, we could put in for a second year. That's where the 3 years came from. The regards to this February is only again so we find out if we did get selected. So if we did, we could proceed. 12 is better, 12 months, so that you do the whole thing. We only have to meet once. But if we at least get to where 1 February, either next month or the month after, we know, then we know we've got something in front of us. We have a settlement, a potential solution to make everyone whole that we can then proceed on the course with. Did I properly answer your question?
I believe so, yes. Thank you. Council, any questions for Mr. Ventura? Councilman Shelley.
Just, I guess, to piggyback a little bit on the mayor's line of questioning, because I do think that, ultimately, I'd love to see a tolling agreement. I'd love to see the parties agree to get us to a point where we as a council have information as far as, is the base selected, is the REPI program selected, and then 2, what's the appraisal value? Because I think where the rubber meets the road in this whole issue, both when you talk about a tolling agreement, when you talk about a settlement agreement, when you talk about the basis concerns about vesting rights now without knowing whether or not the property owners are going to potentially be willing to accept any offer made by the REPI program, because that's really where the issue is here. Is the appraisal of the property going to be a sufficient value such that the property owner feels that that is a just value, willing to accept that value voluntarily and settle to give their rights up and get paid in accordance with it? So I think that I would love to see a tolling agreement, but at the same time, I think that, as the mayor mentioned, getting to February only gets us to was it chosen, which I think is the first threshold, meaning that we need to find out whether or not we even make the cut as the Air Force Base. And if that does, okay, we go on to phase 2, which would be now let's get it appraised, let's see what that dollar value is, and that's really where the ultimate, whether things settle or don't settle, is going to take place, because either at that point the property owners are going to be satisfied that the appraisal meets their level or what they're looking for, what they think is just value, or it's not. And if they walk away and say, no, that this is never going to work for us, the REPI program at that point is not an option year 2, year 3, or going forward, because at that point the whole thing's dead. But I do think that, and I don't think a tolling agreement's on the table based on discussions I've had with the property owner. I think that they are ready to move this down into a venue in which they can have more control and have some set standards. But if there was a discussion that takes place up here, if that ends up being where this goes, I think that you would need, I don't want to set the expectations where February is the date, because ultimately, until you get that appraisal, that's the end time period in which I think all of us, or I would feel comfortable having decisions to be made where I know then either the REPI program is going to work or not going to work at any given time. And then at that point, we can make a more informed decision. So I just wanted to make sure as we start talking about February as the decision date, I think that in the event that that went that way, we've set ourselves up for failure by asking for that date as the only date, because ultimately there's going to be an extension, because none of us, the property owners, the decision makers up here, are going to have enough information on February 1 to know whether this is a win-win or whether we're still going to continue down the same path that we're going on. So I just wanted to kind of lay that. I don't think a tolling agreement's on the table, but in the event that it becomes, I just wanted to at least lay that as the groundwork. So thank you, Mayor.
Thank you, Councilman. Mr. Roy? Councilman Avila?
Thank you, Mayor. Mr. Ventura, could you confirm with regards to the REPI application the weight of the impending or the threat of the suit and the priority that that might give the REPI application? The threat of the lawsuit, does that add extra weight to the REPI application?
I don't score them, so I can't say that with any certainty. I know that the intention is to both of the REPI program is to both, one, prevent encroachment, and the other is a secondary, in some cases, to preserve environmental areas, or in this case, they have now included farmland. So I would have to think that the weight of the potential encroachment itself, I would think would be a factor, but I don't work there in OSD, and we don't get to be included in that. So I can't answer that with any certainty.
Okay, so
with any authority.
I understand. It seems to me that we have the three options. We have option A, where we go into this, we offer the settlement agreement, and we face a potential lawsuit from the base that we have to then defend. Or option B, that we ask for the tolling agreement, and that is declined, and then they sue, the Algers sue, and then we settle later. And at that point, we're still sued by the base to try to overturn that settlement. Or option C, where we do toll, we see what happens, we allow what's already been started to finish, and it keeps the Algers in a position of preference to still be able to sue if that doesn't work out for them. But at least it gives us the opportunity to let things work out on their natural course as it's already been started. I certainly don't want to walk into any litigation, and I think option A and option B both put puts the city in that position of walking into a litigation. So it's definitely a challenging decision. I have so much compassion and empathy for the Algers. I'm so sorry that this has not been resolved within the last 10 years, or that it wasn't addressed back in 1996 when the property was annexed. But based on the information that we have right now, it just seems unreasonable for the REPI package to just be eliminated from all possibilities, because if we settle now, then there's no urgency for the REPI package to prioritize the purchase of these rights. What's done, it's done. They have their rights. Maybe the next 3 years goes by, the rights get purchased. Maybe not, because they already have the rights. There's no urgency. And if we don't settle and we do get sued and we don't see through the REPI program, then we have to be prepared for that secondary lawsuit anyway. So it just doesn't make sense. Option A doesn't make sense to me. Option B doesn't make sense to me. The only option that I see that makes sense for the Algers, for us as a city, for the base, is this tolling agreement to at least take another baby step bite at the apple, see what happens in February. They keep the right to sue. And that's where I'm at right now.
May I say, if we find out in December like we're supposed to, we're not going to keep it a secret until February. Of course, we'll let you know right away. Maybe we all know before Christmas.
Mayor, if I may, one quick question.
Councilwoman Bailey, yes.
You know, I agree. I want to see something fair for everyone. I feel like there have been opportunities in the past that I wish I could have been part of some of those initial ones, and tried to come up with something that worked out for everyone. It does come down to what that assessment, what that number would be from the REPI program if it's approved. So, Mr. Ventura, what would you say the soonest, if it is approved and we find out in January, what do you think the soonest would be that the Algers could hear a dollar amount?
I don't know. I would get the rest of the schedule at that point. Right now, I only have it up through the calendar I shared, which was through the end of December when the decisions come out. I do believe that by the time they get around to all that, I want to say it's probably springtime, I think. I'm not certain. I don't want to tell somebody something that's not true. I could see if there is a further REPI schedule. I'm willing to do that goes beyond. I imagine if you get selected, then they provide you with part 2 of the story with, okay, here's your schedule, here's how things are going to work, step 1, 2, 3, and approximate timelines. And I'm willing to go and ask for that and get it to all of you tomorrow if I can get it. But I don't know exactly when it's done. It's, you know.
From previous applications that you've
It'll
worked
be
on?
sometime during the, 2021. I think that I'd heard that, like I said, I thought I'd heard that potentially springtime is when they would, after all the agreements are made and the surveyors get out there and appraisals are done. It could be something. It could be earlier. I'm not positive. I could even maybe text someone when I sit down, and if I get an answer for you, I'm happy to come back up and give it to you. I don't know what the dates are really.
You know, February, like was mentioned earlier, that doesn't hold a lot of weight just because that's the very first piece. It's an important piece, but the second one even more. So if we could find out a ballpark at least, that would be something worth discussing, because February doesn't give much hope to know when they would have that dollar amount.
No, we would find out, as I said, in late December if we were selected. But I think that if you've been selected and you know you're in the program and you're going to receive then funding for the property, then, if it's at that point, February or March or April when the appraisal gets done, I don't think that's going to impact Mr. Alger in waiting till the appraisal actually gets done. An appraisal takes time. They got to go out there, and I don't know who the appraiser is. We don't select them, so everyone knows it's selected by the partner. And there's 2 of them, and they're independent, and they're done according to something called the Yellow Book standard, which I'm not familiar with. But I know that those in and of themselves take time, so they're not going to be able to turn those around, I know, in I don't think 30 days. I think there's a lot of things that have to be done, and that's how it is. But I mean, it would all happen in, I think, a reasonable amount of time, if I can say that. We're not talking about another year or something.
That's all for now, Mayor. Thank you.
Councilwoman?
Thank you, Mayor. The mayor and I both know very well real estate market, real estate transactions, and just for the rest of my colleagues, the reason why we can't, or the base can't give a number right now to the Algers is because it costs money to do these appraisals and these assessments. So if you consider, if you think about a standard residential transaction, usually you do an appraisal simultaneously with underwriting, but in this case, they're basically being underwritten first. They're determining whether or not the property is priority and if it's going to be approved, selected. At that point, they'll undergo all the costs involved, the surveys, the appraisal, as Mr. Ventura has testified. That's why there's that delay. Otherwise, if everything was done simultaneously, you'd have an answer much sooner than that. But there's costs involved, and they're not going to take the step of the costs until they know they've been selected. And that's just the natural course of things. So I wanted to make those clarifications because I don't see the base acting strategic or with malice intent to try to delay this process, to make this drag out longer than it has to. I see the natural course of a real estate transaction. I see them expediting the process, which gives me a lot of encouragement to see that, or to expect that the same approach will continue throughout the next 30, 60 days, or however long it takes to confirm that it's been selected, and then throughout the following stage of tolling if necessary. And so just to clarify my perspective on how this transaction is being processed, I think it's being processed fairly. I think it's being processed professionally. And I think it's reasonable for us to expect for the Algers' best interest, especially in an economy right now, and I'm going to use the word in a Trump economy, this is the best time to sell those rights to a military that's funded, and for the possibility of your application to get approved because of that added weight of the pending suit. I think that that's a blessing in disguise to your application in the REPI program. And I think it would be a disservice to kind of act prematurely and try to settle in advance and walk into a lawsuit, whether it's them suing us or the base suing us. So I'm still struggling with the decision, but I wanted to share that as well. Thank you, Mayor.
Thank you, Councilwoman. Council? I want to ask, thank you, Mr. Ventura. Is there anyone else in the audience who wishes to speak on this? I see a couple of folks who have authored pieces of correspondence that have been circulated to council. So I'd invite them to come forward at this point, and then if counsel for the Algers wishes to respond or clarify anything that's been said in opposition, if you will, I'd invite you to do that after we hear from the others.
Mr. Mayor.
Thank you, Mr. Ventura. Sure.
Mr. Mayor.
Thank you. You know the drill, Mr. Guzman.
Do you want to give us, do you want to answer the call from Councilman Fletcher first?
Oh, I didn't hear him. I'm sorry. Yes. Thank you. Councilman Fletcher?
Yes, thank you, Mr. Mayor. Sorry I'm unable to attend in person tonight. It sounds like Mr. Ventura has already sat down. Just a quick question in regards to understanding that there are other applications in that REPI package that was provided. Just wondering, was there a funding element or number that was provided to the national program or amount requested that is public record or something that can be discussed, or was it just an application based on there's a section of land we want to look to prevent encroachment on the facility?
Mr. Attorney, did you catch that? I really didn't understand what he was.
Can you hear me any better now?
Either one of you.
If I understood his question correctly, I believe he was asking whether there was a monetary request associated with the application that was submitted. I'm not, but it was hard to decipher.
That is correct.
Okay.
Okay. Hey, so, Mr. Fletcher's question is, was there a cost to any party to submit the application? Mr. Ventura, can you address that for us? Thank you.
If I understood correctly, he was asking if there was I believe he's asking for a land value given or associated with this land in the package. Did I understand correctly? Is that Councilman Fletcher?
Is that correct, Councilman Fletcher? You were asking whether or not a evaluation or an estimate evaluation was included in the package?
Yes, Mr. Mayor, that was my question.
Okay, yes.
There are, I didn't, I have people that do these things for me, so I didn't put the package together myself, okay? There is some values that are put in there which are kind of I don't know how to, let's see, what's the word? Get you in the ballpark. Maybe it might have come from the property appraiser site or something like that. I don't know where it comes from, just to get their head in the game. It has no bearing on the actual appraisal itself. It's, quite frankly, I think it's just to get them in the ball game, because it has no bearing on the actual appraisal. And I don't remember exactly where the figure comes from. There is one, but again, it has no bearing on anything.
Any further, Councilman Fletcher?
I'll reserve time for later. Thank you.
Can you repeat that?
I'll reserve my comments for later. Thank you.
Gotcha. Thank you. Mr. Guzman.
Good evening, Mayor. Good evening, Council, staff. My name is Julio Guzman. I'm here on behalf of the South Dade Chamber of Commerce and its Board of Directors, and I'd like to read something into the record. The South Dade Chamber of Commerce, along with its Military Affairs Committee, has proudly supported the Homestead Air Reserve Base, its military mission, and its military quality of life for over 50 years. The Homestead Air Reserve Base has proven to be an essential part to our national defense while contributing over $331 million into our local economy. The U.S. Air Force is currently considering Homestead Air Reserve Base as a potential site for the F-35 aircraft, replacing the F-16s. Miami-Dade County has proposed locating U.S. Spacecom on a site near the Homestead Air Reserve Base. U.S. Spacecom is expected to generate 1,400 new military and civilian jobs, further advancing the economic impact and quality of life for our residents. The agricultural industry is equally as essential and contributes $1 billion annually to our economy. To ensure the ongoing and sustainable economic recovery of the South Dade community, both the defense and agricultural industries must be vibrant and economically healthy. The South Dade Chamber of Commerce commends the City of Homestead for implementing the 2010 ordinance restricting residential development in the designated APZ1. In 2010, City of Homestead Council came to a viable and fair solution involving property owners, the military, and the City of Homestead, creating a fair and equitable solution for all stakeholders. The South Dade Chamber of Commerce encourages the city to re-engage in similar mediation with all stakeholders to find an amicable solution and fair and acceptable to all parties. The South Dade Chamber of Commerce recommends tolling this vote for 90 days, allowing for the REPI program to continue. South Dade Chamber of Commerce also does not support restoring the residential development rights in the APZ1, nor does it support a lawsuit that will create additional challenges to the city's financial recovery in midst of COVID-19 pandemic. As always, the South Dade Chamber of Commerce is here to help find a solution to any of the problems that the city faces. I'm here to reserve for any questions. Thank you.
Thank you, Mr. Guzman. Any questions from council for Mr. Guzman? Thank you. Is there anyone else in the room or online wishing to address? Okay, we have someone online.
Yes, Mayor. We have some public comments. Russell Black.
Yes. My name is Russell Black. I live at 19485 Southwest 288th Street. I am the military advocacy representative of the Military Affairs Committee of the South Dade Chamber of Commerce. First, I want to thank the mayor and the council for serving our community and for being willing to wrestle with these complex and difficult issues. I also recognize the Alger family is a historic and very significant family in the past and present of the Homestead community, and I can understand their concerns as well. I'd like to finish with a statement to say that the long-term viability and survivability of the base and all of its various tenants is of the utmost importance to our community simply due to the economic impact the base provides to our community. Allowing residential development of any sort in the disputed area would present a significant threat to the base, its current operations, and any future operations that will surely be needed in the future so that the base can remain relevant. And as a representative of the Military Affairs Committee, we just urge all parties involved to do everything in their power to work on a solution that will provide no unnecessary barriers to the long-term viability of the base. Thank you.
Thank you, Mr. Black. Appreciate it. Who's next?
Next, we have Jonathan Borgett.
Yes, good evening, Mayor Osner and Council. My name is Jonathan Borgert, live at 18703 Southwest 295th Terrace in Homestead. I represent the Military Affairs Council. Our statement is, Military Affairs Council has its origins in 1955 in the aftermath of World War II and the Korean War era, when its Civilian Military Liaison Committee was formed in the Rotary Club of Homestead for the purpose of encouraging goodwill between the newly activated Homestead Air Force Base, now known as Homestead Air Reserve Base, and the Homestead and other Redland District communities. Over 53 years, the MAC has carried its mission to ensure the long-term viability of Homestead Air Reserve Base and reinforcing the military family's quality of life. Accordingly, the Military Affairs Council has learned of the potential reversing of the city code that prevents any new residential development be allowed within the accident potential zone 1. The Military Affairs Council strongly supports the protection of the Homestead Air Reserve Base from any activity that would encroach on the base and its operations. As a military advocate, I'd also like to say you guys are in a tough spot. The future of that base is kind of in your hands. We have to consider if a BRAC round, a base realignment and closure round ever occurs again, residential development in an accident potential zone would put Homestead Air Reserve Base at the top of the list if that BRAC round ever comes out again. And as my colleagues have mentioned, the economic impact would be tremendous if the space was ever closed down. So thank you for your time.
Thank you, Mr. Borgert. Who do we have next?
Next, we have Tom Newber.
Thank you. Mayor and council members, can you hear me okay?
Yes, you can hear you.
Go ahead.
Okay, thank you. Well, good evening, and thank you so much for this opportunity to address you via WebEx. My name is Tom Neubauer, and I serve as Vice Chairman of the Florida Defense Support Task Force. As you know, the task force was created by the state legislature with the mission to preserve and protect and enhance Florida's military installations and ranges. The issue that we're talking about has been discussed extensively at our public meetings, and task force members recently voted to send a letter to the City Council to clearly state the position of the task force and ask for your consideration. Thank you for the opportunity to allow us to go on record with a few key points that are in the letter sent from our chairman, which is State Representative Thad Altman. I would ask the letter to be entered in public record as well. The task force strongly supports the protection of Homestead Air Reserve Base from activities that can conflict with the base and its defense missions. We appreciate your partnership as a defense community member. If approved, the proposed zoning would impact base buffering, allow encroachment, and could pose a public safety hazard, and such risks could jeopardize the ability of the Air Force to continue conducting important defense missions from Homestead. The Task Force 2020 Economic Impact Study shows that the U.S. military contributes over $1.6 billion to the Miami-Dade County economy, and much of that comes from the Homestead Air Reserve Base. The military also accounts for more than 28,000 jobs across Miami-Dade County, and many of these are located on Homestead Air Reserve Base or by some secondary effect. So as you know, it's important to consider the reduced safety and the result of encroachment that could impact military value at Homestead as an operating location. And that may invite consideration by the Air Force to reconsider other locations that could accommodate the mission with reduced operating risk. The Mayor and Commissioners, the Florida Defense Port Task Force strongly supports the protection of the Homestead Air Reserve Base. It's important defense missions. These missions must be protected from the potential impacts of proposed rezoning that will allow incompatible development in close proximity to the base. We certainly agree with Mr. Ventura's idea of going with option C, giving REPI a chance. I do want to say thank you for your time, for your longstanding support for Homestead Air Reserve Base, for the defense community that's been around since 1942, and the contribution you make to our nation's defense. We certainly appreciate your consideration for our request. I understand the difficult position that you're in. Thank you very much.
Thank you. Appreciate your help.
Next, we have Rick Miller.
Yeah, thank you. I'm Rick Miller, Executive Director of the South Florida Defense Alliance, and on behalf of SFDA, thank you for the opportunity to speak. Mr. Mayor, we submitted 2 letters to you and the Council in the public record, so I will just highlight a few salient points. We understand the issue before you is a very difficult one. We also appreciate the previous years of steadfast support to HARB from the city and also from the Alger family over the years to both the base and the community and region at large. Our concerns stem from the ramifications of approving this agreement. By attempting to mitigate a potential one-time litigation risk, the city creates the unintentional consequence of adding greater risk by placing HARB at an increased chance of an ultimate closure. That outcome, if it happened, would result in the community losing multiple orders of magnitude and more funding that they benefit from year after year. Quite simply, despite the good intentions expressed previously and this evening by all, this is a risky decision at a particularly bad time. Why does the decision add risk? Viewed from the perspective of multiple former senior military and civilian officials who have worked similar issues at the highest levels of the Defense Department, we feel it sends a signal to the Pentagon that Homestead is softening support for protecting the base. That negative view is likely how officials in similar roles will see this. Why is it particularly bad timing? First, it jeopardizes a successful REPI outcome. Action today to restore redevelopment rights in the future could be viewed in the department as an attempt to force their hand while having the REPI proposal under review. This will not be a good perception in Washington. Second, the calculus to protect HARB is certainly predicated on replacing the aging F-16s with F-35s in the near future, thereby maintaining the core mission. Creating a creeping encroachment risk creates doubts within the basing decision-making processes that must consider those implications for easily the next 20 to 30 years. Third, new opportunities, including the greater economic development that comes with the F-35, the Joint Use Agreement, expansion of the National Guard footprint, and Space Command previously mentioned, are all placed at risk. That outcome would have, and if all of this led to the base being closed, that outcome would have catastrophic impact on the city and its residents and the economy. Unlike tourism and agriculture, defense has largely been uninterrupted in the pandemic and a great economic stabilizer. We feel the action should be focused on growing and expanding that strong defense base and not rushing a decision that places it in further jeopardy. We strongly urge the City Council to vote no today and work with the landowner and the Air Force to successfully achieve a REPI settlement. Otherwise, we fear that this may be linked back to becoming the first vote to ultimately close the base. Thank you and appreciate your support.
Thank you, Mr. Miller.
Next, we have Tim Jones.
Hi, good evening. Thank you for the time this evening. I'm Tim Jones. I'm the Vice Chairman for the Florida Defense Alliance. And for the record, I would like to read in, for the record, a letter from the Florida Defense Alliance Chair, Kelly Jo Kilberg. It says, Dear Mayor Losner, on behalf of the Florida Defense Alliance, I write to share our deepest concern regarding the potential reversing of a successful decades-long partnership between the United States Air Force and the city, which has resulted in compatible land use outside a Homestead Air Reserve Base, ensuring the health and safety of residents, businesses, and U.S. military. Our organization, the Florida Defense Alliance, was created by Florida Statute 288.9801 Bravo to ensure that Florida, its resident military bases and missions, and its military host communities are competitive for strategic basing decisions. The FDA's mission is to identify and coordinate the plans, engagement, and public awareness necessary to provide statewide leadership and support to defense-related people, installations, and missions throughout Florida. Florida's military and defense contribute almost $95 billion to the state missions, to the state economy annually, and more than 914,000 jobs. Home to the U.S. Southern Command, the 7th Coast Guard District Headquarters, and Homestead Air Reserve Base, Miami-Dade County enjoys $7.5 billion annually and more than 66,000 jobs directly and indirectly related to the military and defense, according to our latest study. Of course, contributions flow both ways. Florida's military and defense communities contribute to both our state and U.S. national security. Any local or regional decision that impacts our installations impacts the state and nation. There are multiple future missions, such as potential transition of the 482nd Fighter Wings aircraft from F-16s to F-35 Alphas. The potential location of the U.S. Space Command headquarters in the county, along with joint use operations for Miami-Dade General Aviation, that would likely be impacted with the decision to allow development incompatible with current HARP missions. In addition to creating the FDA, the Florida legislature passed Florida Statute 163.3175 to ensure that land development did not adversely affect the ability of our military installations to carry out their mission or threaten public safety due to the possibility of accidents. The legislative intent is for local governments to cooperate with military installations for compatible land use. Accordingly, the City of Homestead adopted a city code that no new residential development be allowed within the Accidental Protection Zone 1 surrounding HARB in 1991, and again in 2010 as a Homestead Airport zoning ordinance, quote, to promote the public health, safety, and welfare and protect the utility and capacity of Homestead Air Reserve Base, end quote. The FDA has supported the U.S. Air Force studies, state legislation, city measures that have recognized and shared HARB's interest to preventing incompatible land use near HARB. The FDA fully supports HARB's request that the city be consistent with past decades of working together. Thank you.
Thank you. Who do we have next?
That's all we had, Mayor.
All right. Unless I don't see someone, it appears that everyone who's here in person who would wish to speak on this, contrary to the property owners, has had the opportunity to speak. And I'd like to invite the property owners or their counsel to come forward and address some of the comments that have been made tonight.
Thank you, Mr. Mayor. You heard a lot of comments from the defense community and or the chamber about the economic impact of the HARB and about how approval of this settlement agreement will be devastating to the base's mission and will result in a BRAC closure and the sky is falling. And that can't be true, and I'll tell you why. Because on the APZ-1 on the northeast side, there is 1 per 5, and nobody's threatening to sue the county, nobody's threatening to sue that landowner, and nothing. The only comment on that property is it's being addressed. We want to be addressed in the same way, in a fair way. Mr. Ventura has submitted the application as stated on the record. However, he said, the 3 years that we talked about in July came from me being reasonable, and sometimes you just don't get the funding right away. And I think many of the council members and the mayor picked up on this issue. A tolling agreement till February is only going to result in a further request for another tolling agreement to see what the appraisal comes back, and another one to see if we accept the offer, and that's how this process is going to go. That was the purpose for putting the 3 years in the agreement, is the base said, I don't know. There are many unknowns. I don't know if I'm going to get the funding right away. That's why we want the 3 years, and that's why it's in the agreement. February gets us nowhere. April gets us nowhere. August gets us nowhere. It's just going to be further requests for tolling. Another point that has been raised is, well, if we approve this settlement agreement, then the base is just going to sue us. Well, that's a decision that the base is going to have to make. But if they do choose to sue, that 3 years is off the table, number one. And number two, it will be a procedural claim. If we are not able to resolve the claim, our claim is a damage claim. It's a multi-million-dollar damage claim with attorney's fees and costs. So when you're weighing your options here, I think you have to ask, if the base is threatening to sue, why aren't they suing the county on the northeast side? Not only that, but during the pendency of that extended litigation over the 2010 vested right, or the 2011 vested rights determination, we asked, I can't even tell you how many times at the table, look, base, all we want to do is file that PDR application with the county. The USDA pays half, the county pays half. That's all we want to do. We can't do it with this lawsuit pending. Base said, sorry, can't help you. This is the way it is. We're going to pursue the litigation. So now that opportunity has passed, the base is pursuing the REPI, but this process has been going on for so many years, and so the tolling agreement does not solve the issue. In fact, Councilman Avila, you said it's unreasonable because this could eliminate the REPI application and will reduce the urgency. I completely disagree. The urgency is there because this claim is pending. I filed the claim in May. This council met on July and directed us to come up with a settlement agreement, and the base moved right away. For the previous 10 years, nothing. So there is urgency, and there is no evidence that the Algers are not going to participate in good faith. But this is what I have heard point blank is, look, if we get down the REPI process and we offer you a value and you don't like it and you don't agree, we'll just sue you then. It does nothing for us. Approval of this settlement agreement is not going to jeopardize the REPI process. It is only going to encourage it to be successful. If you don't approve a settlement agreement, we're going to litigate over Birch Harris, and I don't know how that's going to affect the REPI process, but certainly approving the settlement agreement is motivating a resolution of this situation. A couple of other comments were, that this could be perceived as softening support for the base. This is just a one-time litigation risk. It's a one-time litigation risk that is 8 figures. So the city has to, at some point, take into account the city and the interest of the taxpayers. This cannot be perceived as softening support for the base. Like I said, they are not threatening the county. They're not threatening any of those landowners. And I just have to reiterate a comment that the mayor made on July 22nd, when the council previously met on this item. He said, I represent the city and the taxpayers. The commander of the base is not answerable to the city of Homestead and is not responsible for balancing the budget. I am. So in conclusion, I would say that the comments regarding the fact that, approval of this settlement agreement is going to result in a brat closure or jeopardize the REPI process, the opposite has to be true. We respectfully request that you favorably consider the settlement agreement, and if you have any further questions, I'm available as you discuss.
Thank you. Councilman Roth.
Thank you, Mayor. I do have a question for the attorney. And you just made a statement that you wanted to be heard. And I think you are being heard. And I think the Algers are being heard. In fact, this is the 3rd time you've been in front of us. So my question is, what would waiting 90 days hurt?
The 90 days would mean nothing, and that is the point.
I'm just specifically talking about 90 days.
Exactly, because when we were here in July, the request was 90 days. So tonight, the request is 90 days again. And in February, it will be another 90 days. Not going to solve any problems. In February, there will only be a snippet of the information that's needed in the REPI process. It will just be another request for a tolling, as noted by Councilman Shelley and Mayor Lassner.
I get that. So my question again is, what will hurt waiting 90 days?
Because 90 days will not be the request. That is what.
Right, but in 90 days, we get a response. It's either going to be yes, they're in the process, or no.
Right.
And then we can come back here in 90 days and do what we have to do.
Right. In the agreement, we gave 3 years of not pulling a building permit to allow the base to secure that funding at the request of the base, because they said, we need multiple funding cycles to get this done. We gave them 3 years, not 90 days, 3 years.
I get it. Okay. So you're not willing to wait 90 days?
No.
Okay. I have another question for Mr. Ventura as well. And my question is going to be similar in regards to the 90 days, but it's not the same as that question. If this agreement were to pass tonight, or maybe let me rephrase that. Having the 3-year period of time in this agreement, how does that affect the REPI process?
It depends. There's a lot of variables everyone's trying to figure out. It depends. Probably, I think you're making an assumption. So we're saying if we were to toll this till we get a decision, and you're asking if we get a decision, and we are accepted into the REPI program, we're going to get funding. You are asking what the 3 years, how that plays into that?
No.
I'm sorry?
If it was decided tonight to accept the settlement agreement, is there any part of that agreement inside of including the 3 years, that affects anything to do with the REPI process?
Oh, well, certainly, because what it's done is you've already settled the case. And so if you do that, the case is already settled. As I put in my original comments, there is no incentive or any need for the Algers to settle further. It's already been settled. So if you accept the settlement tonight, that's kind of it. There's no need for them to settle further. You've already given them full development rights, the base is encroached on, and then that reverberates out. So that's the difference. Right now, we're at the negotiation table. We can find a win-win solution for everyone, and we can reach an agreement, and we have that ability. But once one of us gets up from the negotiation table and walks away, which they will tonight if you settle, then that's pretty much done. There's no need or reason for them to settle further.
Well, we've heard this a few times because there's a process, there's the appraisal, and at some point, there's a dollar amount that will be discussed.
Correct.
And regardless of what happens with their vested rights or not, they could agree to accept that, or they could not agree to accept that. So we want to solve this in the most amicable way we can. We were put in this position by previous decisions, and I don't think there's a way to settle it right now, today. I just want to say that I've supported the base for a very long time. In fact, back in 1993, 94, I was a part of a group that went to Tallahassee to fight to keep the base here after Hurricane Andrew.
Thank you.
So another thought I had was no one who spoke tonight in support of the base mentioned protecting the city of Homestead. And that's kind of what we have to do up here, is protect the city of Homestead. The base is an asset. Homestead Miami Speedway is an asset. We want to protect those things too. But I think our ultimate goal as elected officials is to protect the city of Homestead. There has to be And there hasn't been an amicable solution between the Algiers and the base. And I don't know that there will be. I don't know that it'll ever get settled. I don't know that there'll ever be a house built on those properties. I don't know that the base is going to ever buy their rights. But I do know, based on their statements tonight, that they will file a potentially $13 million lawsuit against the city. And it's hard for me to swallow that. To put the citizens and the taxpayers in that position. I love the base. I would do just about anything I could for the base. But my responsibility is to protect this city also. We're put in a very particular or peculiar situation. And again, I'll say it. I didn't hear anybody tonight talk about protecting our city. But I went up in 93 or 94 to protect our base from being taken from us. There aren't too many people that can take the city of Homestead away from us. But we have no control whether the base will be there next year, regardless of what decision we make here tonight, to protect you or give them back their rights. That's all I have, Mayor. Thank you.
Thank you,
To
Councilman.
address you, if I may, my opening statement did state that waiting until December for the results would protect the city and the Algiers and the base by getting all of us where we needed to be. Thank you.
Thank you, Ms. Ventura.
Mayor?
Yes. Vice Mayor?
Yes, thank you, Mayor. So I've been here intently listening at everyone's position, and I read all of the information that has been forwarded to us via email. And we're really, really, really in a tough spot, a very tough spot. I believe everyone on council has had long-standing support and commitment to our Homestead Air Reserve base, and we respect the value that the Algiers bring to our community. So having to make this decision puts us between a rock and a hard place, so to speak. But I agree with a lot of what has been said tonight by my colleagues, but the most compelling to me was what Councilman Ross was articulating. Who indemnifies the city? We have to make a decision that is in the best interest of our city, irrespective of the basis position. We have to think about our residents. We have a fiduciary responsibility in order to do that. And $13 million is a lot. It's a lot. And in a perfect world, the Algiers would agree to the tolling proffer, and I would hope, well, I had hopes that they would, but it doesn't appear. It's clear tonight that they are not. They've drawn the line in the sand and saying, this is it. So in light of that, I'm not sure I am comfortable with not agreeing to the settlement, because it just gives us so much exposure. And I waited to speak last to see if there would be any shift or pivot from the Algiers to wait until December, but it doesn't appear that that's going to be the case. So I'm not sure that I'm willing to expose the city to that sum of litigation. And I'll rest there for now.
Thank you, Vice Mayor. Councilwoman?
Thank you, Mayor. So I wanted to get clarification because I feel like we're all speaking in terms of settling during a mediation. I know that there was a claim made, but if they file suit, then there will still be an opportunity to mediate and settle at that point, albeit a modified settlement agreement. I doubt there will be a 3-year waiting period in that one. But if we settle prematurely, then we definitely are losing the opportunity to get to that point, to see the REPI application, And we're voluntarily setting that precedence on overturning an ordinance that's been there since 1991, then again in 1996 was annexed, and then in 2010, 2001, 2010. I mean, this is years and years and years of ordinances that we're just voluntarily walking into overturning without a lawsuit being filed. There will still be the opportunity to settle and get to a negotiations table again. So I think that there was a lot of pressure on us to settle in advance because of the uniqueness of the Burt-Harris Act. But that's typically not what's done. We get sued, then we mediate, and we try to settle and stay out of court. We're skipping that process. I just wanted to remind my colleagues. Thank you.
Thank you, Councilwoman. Councilman Shelley?
Mr. Mayor.
Oh, all right. Go ahead, Councilman Fletcher.
Yeah, can you hear me okay now?
Yes, a little better.
Okay, so basically, first and economic impacts tonight, and kind of following the same thought process as Councilman Roth and Vice Mayor Faircloth. Again, we have to look out for the best interest of the citizens of Homestead. We've heard a lot of assumptions made tonight on both parties, but there's one fact that's basically been stated tonight, that if we don't do this, we're going to get sued. The city of Homestead is going to have a lawsuit. And with that, that places the taxpayers at risk. Like my other colleagues, I think everybody who sits up there supports the air base and its mission here in South Florida. But there is no direct connect in assisting us if we get sued and we lose this case. The taxpayers are on the hook for this $13 million potentially and attorney's costs. And I think that we would be neglecting our duties if we did not really focus on that as the priority of this discussion tonight. This right now is also, Mr. Aldridge stated it earlier, his land basically has zero value in its current state, and he's not able to utilize those funds to help operate his company, which has been a long-standing business in both the city of Homestead and the county. So I think this potentially helps all parties involved if we move forward with this. I believe that if the base really wants to continue to, support our community, that they will find a way to continue this process on. Again, there's 3 years that the Alders are not going to be doing anything with this property. That's what they're offering, 3 years for them to go through this process. So I think we all need to think about that. That's all I have. Thank you.
Thank you, Councilman. Councilman Shelley?
Thank you, Mayor. Just, I guess, to weigh in kind of where I am right now, this is one where, again, I think, as everyone stated, I mean, we as the city have been put in a very bad position. I mean, we're kind of a rock and a hard place. Policymakers, we want to protect the base, as all of us have stated. The base is a big economic engine as well for the city of Homestead. Generates a lot of dollars that get spent in our city based on the people and the reserve officers that are working there on the base. And so you want to protect that at the same time from a property owner's rights. You don't want a property owner's rights to be taken from them without just compensation. And I think in this case, it's a situation where it's a legal determination. The Algers have their arguments and their strengths of what they believe their rights are. The base has their own version as far as what they think the rights are, and that the property owner doesn't have rights. And so that becomes a legal determination that ultimately a judge, with a lot more knowledge, is going to sit down and make that determination on which set of facts are in fact maybe correct. But ultimately, if the property owner is entitled and has rights and those rights were taken, they should be compensated. I agree with that 100%. And so that's kind of where we in the city are stuck, though, is we're kind of stuck between wanting the property owner to be compensated if they're due compensation, but at the same time wanting to protect an economic engine and the Air Force Base from a protectional standpoint. But ultimately, if we go through the litigation and we take on that burden 100% on us, and we lose, then it is the taxpayer that ultimately is going to be ponying up and having to make that payment. I mean, it's going to affect our reserves and everything to that nature. So I don't know that litigation, especially at this point, without enough facts, I think the same thing. The attorneys haven't gone through discovery. They don't have all the information and details yet, so they can't even really advise us as far as what our chances of success would be on this particular case at this point in time. It's still in the infancy phases. But at the same time, I'm not ready to settle either. I think one of the big concerns and really where the crux of this issue is that if the rights are granted immediately on the front side, then at that point in time, there is no motivation per se for the property owner to settle, although I do believe that the Algers want to settle. I don't think they want to build houses. I think they want to get just compensation, but that again, as I stated earlier, becomes the real issue here, and that is ultimately what this REPI program generates as far as a dollar value. Is that in fact going to be considered just compensation for the property owner? And I think that's the big unknown for the property owner, because they don't know what that value is going to look like, and so it becomes this chicken or egg thing where the property owner is not going to agree to be bound by an appraisal that they don't know the answer to. But at the same time, the base is concerned that if the rights are given on the front side, the property owner may decide to shop those rights around and find somebody that will pay them more than the appraised value, or maybe it is worth building houses on the property to some extent. And so you have this kind of fear factor, whether either party would actually follow through with any of that, no one knows. But that becomes kind of the crux of the issue. And so for me right now, where I'm kind of on this case is that I think that, I'm willing to initiate, I know the Algers ultimately going to file their case, and I think that the reason being is they need to get control of this process. They want to have a finite beginning and a finite end and know that there's a process to reach so they can put this behind them. And I don't blame them for wanting to do that at all. I'm willing to take on some of that risk on the front side from the city to get us through at least this first part of the REPI program, to allow it to play out, to allow more facts to come out through some of this process. And ultimately, hopefully, the REPI program is approved, phase one. The appraisal comes back with a value and a just compensation that is good and fair for the property owner, and it ends up being resolved, but I'm not comfortable settling it today. I'm willing to let it play out for a little while, knowing that it may cost us some money. And that's kind of where my position is. Because I think tonight, the tolling agreement's off the table. We know the property owner is not interested in that at all. And so our options today are either we approve the settlement agreement as is, or we ultimately determine that we're not going to approve it today. They will file the suit, and we ultimately will have to defend it for at least a period of time while we are getting more information, the REPI program running its course, and then ultimately, when that information comes back, or if they're not chosen for the REPI program this go-around, then at that point, I think, even I would concede that I'll be in a position where I would encourage settlement and move it on and be done with the process. So that's kind of where I am tonight. Thank you, Mayor.
Thank you, Councilman Shelley.
Mayor?
Councilman Roth?
Thank you. Just to follow up on Councilman Shelley's conversation, or maybe James or Matt, you could explain that if we don't give the settlement agreement tonight and they file suit next week, can you give us a time frame and maybe a dollar amount it may cost us to go through February and then come back and make another decision if they can't get the REPI process approved? I mean, because it's dollars and cents at this point. Who's going to spend what dollars to make what happen? And if the Algers were willing to go the 90 days with the understanding that they may come back here in 90 days and get the same thing they're going to get, or not tonight, then we might be able to avoid all of this, filing lawsuits. And then I have another question to follow up, but do we have time once we say maybe we don't approve this, we get through the process of 90 days, and then we can come back and make another decision? I mean, how long is that going to take?
Well, I'm not sure I understood the second piece of your question. So we don't do this, we get through 90 days, and then,
No, we don't get, let's say we don't do the settlement tonight.
Mhm.
They file a lawsuit next week, like
Mhm.
they say they're going to do. We drag this into February, waiting for the REPI process. Can you give me an estimated cost? And we're not going to settle in the 90 days, I know that, but we can always come back and make another decision based on that lawsuit that they file, if they do file it.
I'm reticent to put a number on any cost of litigation based on a truncated time frame. I think that, and I understand your question, can we stretch this out a little bit so that we have a little bit more information in the future? I would caution a certain approach because I feel like once we get sued, it's incumbent upon us to defend the city as best as we can. And if we, within 90 days, will we begin discovery and then deposing experts?
I understand.
So, I'm reticent to put an estimated figure on it. There is generally a ramp-up time, but we'll have to respond to the case long before to their complaint long before the 90 days. And so work will be done to defend the city and defend the case. There's no way around that.
Got it. So, and maybe, Kate, I don't know if somebody can answer this question. If a lawsuit is filed against the city, how does that affect us in any way as far as financially, whether it be anything that we've got in the works, any grants, any loans we may have to go after, any type of situation that a lawsuit of this size, if filed against us, would hamper us to continue to do some of the business or any of the business of the city?
Well, I think much along the terms of what Matt was saying, it's hard to understand at this point how it would impact. It wouldn't stop us from going forward with anything trying to get grants, but obviously with the potential of a lawsuit, it comes into play. I mean, as the councilman mentioned before, how it could potentially hit our fund balance eventually, but early on, it's not going to impact how we're going forward with the business of the city.
Okay, so it doesn't help, it doesn't hurt our bond ratings or anything like that. It doesn't affect anything.
I'll defer to our attorneys on that, but at this point in time, I don't believe
I mean,
it would
because it's a
impact
lot of
our
money.
bond
It's not
ratings.
$50,000. This could be upwards around $13-14 million when you're starting adding attorney fees and all that stuff in there too.
And as I say, I could defer to our attorneys to comment on that. Certainly, if there is a pending potential $13 million lawsuit at some point in the budget process, it would have to be addressed that this is a potential liability to the city.
Doesn't quite answer my question, but I understand what you're saying. Thank
Yeah,
you, Mayor.
and Councilman, I don't know exactly how it would impact and when it would impact the bond rating, or I don't know the answer to that question.
All
But
right. Good enough. So basically, everybody's saying it would be okay if we were in a lawsuit for $15 million. Is that kind of what everybody's saying? It wouldn't affect us in any way.
no, I'm not saying that. I'm saying that I'm not sure how and when it would affect us. But if the lawsuit were filed tomorrow, it wouldn't impact how we're going forward operationally right now. I'm sure there's a point in time when it would impact us in terms of our CAFR, in terms of our bond rating. I don't know exactly when or how, but we can certainly look into that and get back to you on that.
All right. Thank you. That's all, Mayor.
Thank you. And I would,
Mayor,
Mr. White.
if I could, just for a moment, to add to what Mr. Pearl's response to Councilman Roth. So the scenario that you laid out has a built-in assumption, and that assumption is that we would be able to settle the litigation if we were sued. And I just think it's important for you to know is that although we would hopefully try to solicit a settlement, we have no control over that and the terms and conditions of what that settlement. We can't force the Algers into a settlement, and so there's limited control on our end with respect to what that might look like, the terms of that, even if we were able to get there. So I just think that was an important distinction to make.
Thank you, James. And I'm willing to go the 90
Mr. Mayor?
days. I'm willing to go the 90 days along with my colleague here. there'll be some equity that will be expensed out on this, but I want to see this thing kind of play out at least for the first 90 days in the REPI program. After that, we can settle the suit by, I guess, basically giving the rights back, and then it goes away. So I'm still torn, but I think if we can come up with that kind of a compromise, and if the Algers were willing to let us go the 90 days and see what happens, I know he's already said no, and he's very enthusiastic about that no. But in the end, you're going to get what you want, I think, anyways. So that's all. Thanks, Mayor.
Yeah, I just wanted to, Councilman Roth, and to the manager, wanted to interject the first thing that came to my mind when you posed the question, Councilman, about the impact that would have, the filing of that suit would have on this, not only the city's ongoing operations, but you mentioned bond ratings and other issues. But the first thing that came to my mind was, and we addressed this early in the budget discussions, was that we're going to be applying to refinance the debt on the old City Hall property. Like you know from your personal, your line of work, that when you go apply for a loan, you've got to disclose those potential liabilities. And when you look at our balance sheet now, while we were looking into couch cushions for those famous pennies, nickels, and dimes just 6 weeks ago, a lender's going to look at us and look at it in terms of the risk that this city has for financial obligation, whether it's settled or goes out to judgment, and look at us and laugh about a potential refinance. That's my fear. The first thing that came to my mind was the issue of the disclosure of that suit in the process of refinancing the old City Hall property. So, just a point that came to my mind in response to your question. No, this year, right now, the day-to-day operations, probably not. But long-term doing business, absolutely. Absolutely so.
Mr. Mayor?
Yes, is that you, Councilman Fletcher?
Yes, thank you. Just something that came to my mind as well, being part of the city council back in 2000 when we found ourselves in running a deficit in our budget, there was a very high probability of the state stepping in and basically removing us from office and putting in a special board to run the city of Homestead. If there's a potential that we're not doing the best job we're supposed to be doing for our citizens. So that's something that can always come up as well. The governor can come in and basically kick us out of office and put a state-run board in here to perform our current duties. Something to think about. Thank you.
Thank you, Councilman. If there's nothing further from council or council, I would entertain a motion for approval of this matter. Do we have a motion to approve the settlement? Moved by Councilman Fletcher. Do we have a second? I'll second it to move it forward. Anything further from council? Madam Clerk, let's have a roll call vote on the motion to approve the settlement as presented.
Councilwoman Bailey?
No.
Councilman Roth?
No.
Councilman Fletcher?
Yes.
Councilman Shelley?
No.
Councilwoman Avila?
No.
Vice Mayor Faircloth Staggers?
No.
Mayor Losner?
Yes.
The motion fails.
Right. So, in light of that now, it's my understanding we have certain obligations under the statute that governs the course of dealing with the Bert Harris claim as was submitted back in May. And I think it's incumbent on us now, and our attorneys are going to need some direction from us as to what our next response would be to the potential claimants. And I don't know, maybe we should start from the laundry list of options available to us as the the formal response that's required of us by statute.
Mr. Mayor, yes, I'm happy to do that, Mr. Mayor, but I think from a procedural perspective, I'd like to start with, because there's some discussion about the tolling for this in the 90 days. And the way that the statute works under the Harris Act claim is the Algers submit to the city, notify the municipal government, and then we as a city have a certain amount of time to respond to that claim with a letter of permitted uses and a written settlement offer. And I'll get to there's a laundry list for various things that can be, that are available to us with respect to a written settlement offer. And I'll get to that in a moment. So that initial 90 days, the Algers agreed to an extension through Friday, November 6th, in order to give an opportunity for you all to consider a proposed settlement agreement. I think the Algers have indicated that they're not going to extend that time frame. So we, as a city, have to, under the statute, provide a letter of permitted uses along with a written settlement offer to the Algers on Friday. And then that's the last prerequisite for them to file their Harris Act claim. We don't have to do that, but I would not recommend that. I mean, at a minimum, one of the things in the statute, the last thing with respect to options could be that the city chooses not to change its position or offer anything at this time. I mean, that could be part of the written settlement, but at least it shows the court that we responded and we did our part with respect to the requirements under the Harris Act. Or we could take a different approach. You could modify the existing settlement agreement to, make some written settlement agreement or proffer that would include the existing settlement agreement and add something else to it, or any of the enumerated items that are in the memo that I provided to you that are in your packet, which is under, I guess, page 2 of 3. It's Exhibit 1 of the CAR, and identified there pursuant to the statutory provision are the various ways in which we as a local government have the ability to effectuate a written settlement offer. And it can include any of those things. And as I said, the very last thing is no changes to the action of the governmental entity. So I would just ask for some direction at this point from you all as a body as to where you would like to go. What am I supposed to write, proffer to the Algers by the Friday's deadline?
Okay. Thank you, Mr. White. And I guess while the Algers and their counsel are here, and I don't know what difference it might make, let me just throw this out there. With the adoption of this agreement before us, with having an effective date of the implementation of the rights as of February 1st, do anything. I mean, the agreement is adopted tonight, but the rights aren't vested until February 1st. That would seem to allay some of the concerns some of my colleagues had about waiting and see what happens, but that you've got a definite agreement in hand. Well, while they're talking, Councilwoman.
Thank you, Mayor. I like where your thought process is going with that, because it keeps the current settlement agreement pretty much on the table. But I think what I would prefer to see is more of a phasing of that, phasing in to see the final outcome of the REPI program. So while I'm interested in hearing what their response would be, I don't know if that ultimately is something that I would be in agreement with if it automatically rights go into play February with that particular date. I'd like to still see a phasing, some type of phasing approach to seeing the outcome. Thank you, Mayor.
I mean, I hate to try to negotiate and come up with solutions here on the fly on the public record, but we are all under the gun. Councilman Shelley?
Just, I think I'll echo a little bit of Councilwoman Avila's concerns. The one thing I think that the problem with having it go ahead and vest on February before we know kind of how the process is going to play out is we get back into the same situation, which is they have a date certain where they know they're going to have their rights, or they already have their rights, and the way it's currently proposed. But then you would have a date certain they would have their rights, and so it goes back, I think, to the same original concern with the existing agreement, which is at that point there may not be any motivation to fully implement the process, and again, I don't know that I'm not saying that that's going to be the case. I think you guys want to get your monies from the government, and hopefully it's a good offer from the government, everything plays out. But as far as a worst case scenario for all circumstances, that ends up being the situation where all they need to do is just wait through February 1, regardless of how the REPI process plays out, or regardless of what offer comes in from the appraisal through the REPI process, and they will have their rights again. And again, I think that gets back to where the crux of this issue is on the existing settlement agreement, is trying to have that balance of, one side's afraid of this and the other side's afraid of that. And so that would still have that same issue, I think, for me. Thank you, Mayor.
Thank you, but, implicit in all that seems to be a recognition that the United States is not going to offer a sufficient amount of money based on the appraisal. The settlement agreement covers that issue, but let's hear from the Algiers representative.
Good evening. Good evening. Thank you for the suggestion, Mayor. I have talked to the client, and if the effective date of the agreement was February 1st, but the agreement was approved tonight, that would be acceptable.
That was my thought process, that it was adopted tonight, but the vesting of the rights would be effective February 1 with adoption tonight or prior to the 6th, whatever, is necessary.
Even if the agreement is adopted tonight, there is an incentive for the Algiers to continue to participate in the REPI process, and that's money. I mean, we have to remember that. It's not like, this is some theoretical thing. There will be an offer through the REPI process, and the incentive is money.
Well, and let's not forget, there will be an opportunity if, hypothetically speaking, there are a lot of ways, for example, under the Harris settlement laundry list, many ways that the city can, let's say, contribute to sweeten that pot if necessary, if what's offered by the REPI program with the partnering of the county, that gives us all of us the opportunity to come back and figure out a way to get there from here. A low offer is not necessarily, or a low appraisal, because as I understand it, the offer is the appraised amount. It is what it is, which to me is a far better scenario than gearing up for certain litigation where we're going to have to hire our experts to do battle with your experts. Somebody talked about looking out and protecting the best interest of Homestead. There will be money expended, significant money expended by the city of Homestead to defend a Harris Act claim between now and February 1st. You can be assured of that. So, Council, I think you've heard their suggestions. Yes, Vice Mayor, thank you. I'm sorry.
No, it's okay. Thank you. And thank you for proffering that. I agree with Councilwoman Avila. I really like your thought process. And the reason I voted no to the settlement was because I believe in meeting in the middle. And I feel that waiting just a bit to get another bite at the apple would be a great way to meet in the middle, although I recognize that the Algiers have been waiting for years. I was just thinking, as opposed to locking us in to February 1st, and I'm not completely against the idea, just wondering if we can leave that just a tad bit open-ended, because there are still some unknowns. We don't know how much the funding allocation will be. We don't know the appraisal. But if we can reconvene after we receive notification as it relates to an awarding of funds from the READY process. But we don't know when that date is. So the February 1st, it may kind of lock us in to automatically approving a settlement agreement if we don't have all the information. So can we just reconvene at a time when the information is available? Is it absolutely certain that we'll have the information by February 1st and we'll be ready to approve settlement?
That waiting to see in February if something else is going to happen is the request for the tolling agreement, and that's not on the table at this time. The Algers would be willing to approve, to have the agreement approved with an effective date of February 1st as a compromise.
Thank you. Ms. Ventura?
I think, if I understood, I'm more inclined to listen to the vice mayor, if I understood, because as we're saying here, we're just talking about still providing the rights, which is still a settlement, but by 1 February, if I'm understanding, 1 February, all we're going to know is if we've been accepted. As the vice mayor, I think, is pointing out, we're not going to have a price yet. There's still a process to go through, and so we're nowhere near completion yet. So I don't know what 1 February gets us. If the suggestion is, and of course it's not up to me, it's up to you, but if the suggestion is just we do this 90 days, I'll call it a tolling period, but we're bestowing rights anyway, but as of February 1st, I don't know where that gets us. We're not going to be able to buy any rights or even have an appraisal for those rights by that time. All we're going to know by that time is whether we've been accepted or not. So I don't think that's a valid place to go. That's only my opinion. I just wanted to give it, make sure I understood, and I'm going to sit down now.
Thank you then. So to me, your comments validate the concerns of the Alger attorney, that it always was going to be moving that ball down the court or kicking the can down the road or whatever euphemism you want to use, that, you know, 1 February seemed to be a good date, and now it's not. So, you know, I think we've smoked out what's really going on here. Not that I ever really had a question. Let me go ahead and say it and be really clear. Approving this settlement tonight, the fate of the free world or the fate of Homestead Air Reserve Base does not rest on having approved this settlement tonight. But by not approving something that avoids Bert Harris, puts the city of Homestead, I believe, at grave financial risk. Period. End of story. It's been going on too long. We've got to pull the trigger tonight on something that's acceptable to the claimants to put the city somewhat out of harm's way, at least for a period of time.
Mayor, if I may.
We are not moving the ball. I've told everyone that the REPI process is a process. That's why we asked for 12 months up front, so we had a time to do the entire process and come back with an actual figure to offer. The other figure in February 1st was only offered when the first one was rejected, so we could at least tell you whether we had gotten accepted or not. We are not moving the ball. We have submitted for the REPI process, and it is a process which takes months to get it all accomplished, which is why we asked for the 12 up front.
We all understand. Vice Mayor?
Thank you. I'm trying to figure out how I can help both sides here. We already did not approve this settlement agreement tonight, and although I'm not crazy about the idea of waiting until February 1st because I'm not sure that we will have all the information then, this is the best I can do to meet in the middle. So if there's a motion, I support it.
There is not a motion. Would you like to make that motion?
I'll be willing to make the motion.
All right. So the motion would be All right, the attorneys are giving me some hand signals, Vice Mayor, so let's listen in.
Hey, I'm sorry, I think James and I are looking for a little bit of clarification on exactly what the motion is and what the proposed change was for the February 1st date, because you and Ms. Hand said two separate things. You spoke about the rights vesting in February 1st, and Ms. Hand had referred to an effective date for the agreement of February 1st. The two things are not exactly the same. And that does have implications, and I don't know if there's a difference to what everyone's willing to agree to there, but if that is the motion.
But again, that's the risk of off the top of the head.
Yeah, no, I just.
Let's hear from council, and then we'll hear from you.
Yeah, I did clarify with the city attorney that they proposed to make a revision to section 2 that says the rights will vest on February 1st, but the agreement will be executed now, and that is acceptable.
So, I guess in shorthand, potentially approved tonight, having an effective date on February 1st, 2021.
Having a vesting date on
Vesting
February
date.
1st.
Okay.
The agreement would take effect, the 3-year tolling period would begin, the vesting of the rights themselves would commence on February 1st.
Okay. Did you catch that, Vice Mayor?
Amendment.
I caught that.
Okay.
I'm okay with that.
Very good. All right. Do I have a second? I will second that motion then. Have any further questions or comments from council before we have a roll call vote? Madam Clerk?
Councilman Shelley?
No.
Councilman Fletcher?
Yes.
Councilman Roth?
Yes.
Councilwoman Bailey?
No.
Councilwoman Avila?
No.
Vice Mayor Fairclough Staggers?
Yes.
Mayor Losner?
Yes.
The motion carries.
Thank you. From our attorneys, is there anything further we need to do on this matter tonight?
No, we'll take care of that change and coordinate with the clerk and getting it fully executed.
Thank you. Anything further from council? Okay. Madam Manager, and incredibly, I've not been keeping up with the weather news today. Do we have any updates, any thoughts on where we might be going with what the weekend might bring that we want to start talking about publicly?
The last that we heard, there was going to be a lot of rain and potential flooding, but nothing since, I haven't heard anything since this afternoon, unless there's something this evening I haven't seen yet.
Thank you. Do we have a motion for adjournment? We have a motion and a second. All in favor? Thank you all. Appreciate your time.